Within 2-3 days you have to file it, otherwise nothing remains in the matter. Yes, call the list.
Daily list item number 1.
The learned advocate representing the petitioner on instruction would submit that the petitioner seeks leave to withdraw. Now,
My lord, 2, my lord, second para, 4th line, my lord. First,
are you withdrawing or what you are doing? Correction.
correction.
Yes.
19 days, my lord, only 19 days. It is wrongly written.
This matter has come up at the instance of the petitioners. Full stop. Since it appears that it appears that in the order dated 18th June 2025,
Item number 3.
I'm a friend of property election commission. In the order.
yes, you are there.
I am for the petitioner, but the matter was disposed of. Someone has mentioned because.
Yes, Lordship, in the order sheet,
Yes, key details.
it is written 17/5/25.
It appears that in the order dated this matter, it appears that in the order dated 17th June 2025, the same has been wrongly recorded as 17th May 2025. Full stop.
Item number 4.
At 4, I am for the petitioner.
Yes.
Please, my lord, somehow, my lord, although they have served before the judicial, but I have been engaged without any copy, my lord.
Sorry, what is this, sir? This is item number 303.
I understand, my lord.
March,
Yes, I'll take it up. Sorry.
my lord, this is the affidavit of service.
Give him a copy. Give him a copy now.
My lord,
Yes, what is the matter?
my lord, here, my lord, this is second round of litigation, my lord. In the first round of litigation, my lord, Honorable Justice Bharadwaj, my lord, passed the order in the month of February, directed the appellate authority to pass order, reasoned order after giving opportunity of hearing. Thereafter, they issued notice. I submitted reply and requested for personal hearing. They did not record my submission in the appellate order and also not given, my lord, opportunity of personal hearing.
Where is the order passed by the Justice Coordinate Bench?
My lord, page number 172, my lord. Starting page. Operative part, my lord, 173. Very small issue, my lord. Copy, please.
Yes.
And my lord, my reply, my lord, starting page 180.
Kindly place 173.
173, my lord. At the as the notice of hearing has been issued to the appellant giving the next date of hearing, the appellant have already submitted their reply. The appellate authority has not passed any reasoned order till date. It is requested by this court to the appellate authority to conclude hearing after giving an opportunity of hearing, pass reasoned order as early as possible, my lord. Thereafter, my lord, they issued another notice at page 174, my lord.
Yes.
And I submitted reply, my lord, page 182. Kindly have a look, my lord.
180.
182, starting page. This is the acknowledgement and operative part from 184.
Yes.
And my lord, I am drawing, my lord, kind attention, my lord, page 190. Last para, my lord. May I read?
Yes.
190, last para. Again, para 12. We are also requesting you to provide opportunity of personal hearing by sending notices of personal hearing such and such, my lord. And next para, my lord, 13. On 13 to 2025, Honorable High Court, Calcutta, WPN number such and such, directed the appellate authority to pass reasoned order after giving reasonable opportunity of hearing as early as possible. This, my lord, they pass the order, my lord. Order at 192, my lord. Starting page, my lord. This order.
Lord, Lordship, Lord Justice Bharat's order, my Lord, Lordship will find, my Lord,
One.
the reply has, they have already filed their reply. It is written, my Lord, that they have already filed their reply. So, my Lord, again, the opportunity of hearing should be given. And thereafter, my Lord, they ask for personal hearing. My Lord, personal hearing.
No, it is request. I confused it initially.
My Lord,
It is
very
requested by this court to the appellate authority to conclude hearing because it was a request. So the appellate authority thought that the appellate authority can refuse to adhere to the request. After all, the court has requested the appellate authority. You see, the language of the court is request. So he thought that I can avoid the request. Yes, who has decided this? Who has decided this? Concerned officers should be personally present before this court. Let them come.
And yesterday night,
Yes, yes. The court has made, in this language, the court has used the word request. And you are again arguing on that. Despite the order dated 13th February 2025, providing for an opportunity of hearing to be passed,
issued a notice and asking to submit a stay order within 2 p.m. today.
stay is already granted.
Yes.
You go.
Affidavit of service. I'm grateful, madam.
I am not going to adhere to his direction.
No, yes, madam. My duty, my lord. my
The order has been passed. Now it is
Yes,
for you to
yes,
communicate. You are
yes.
liberty to communicate this order. Liberty to communicate. Liberty is granted. Liberty is granted to the petitioner's advocate on record to communicate this order to the concerned authority.
Item number 5.
ওইখানে আরেকটা ল্যাঙ্গুয়েজ লাইন লেখো তো আবার পড়ো তো অর্ডারটা সরি ওনার সাবমিশনটা রেকর্ড করা হয়নি The petitioner complains, the petitioner complains that despite the order dated passed by the coordinate bench of this court in WPA number, ওই পেজ ওখানে আছে একবার স্টিকারে আছে হ্যাঁ তারপর
Lordship may kindly accept the affidavit of service, affidavit of service, your lordship.
yes
Your lordship, the petitioner is engaged in gas distribution.
ওই মামলাটা এফিডেভিট অফ সার্ভিস দেয়নি আগেরটা ওটা তো এফিডেভিট অফ সার্ভিস ফাইল ইন কোর্ট ইজ টেকেন অন রেকর্ড yes madam
Your lordship, the matter is related to excess claim of ITC. But this case was not entertained in the appellate stage because there was a delay filing of appeal, your lordship. Your lordship, the petitioner could not file the appeal because he is physically handicapped and he is very much dependent on his employees for the filing of appeal. And when it comes to
extent of handicap
physically handicapped, your lordship,
extent
50%. Your lordship, the certificate is
which page
your lordship. Page 19, your lordship.
9
19.
yes %50 disability yes
Your lordship, and after that, subsequently, the bank account gets attached, and the appellate forum dismisses the case on the ground of delay of 148 days.
yes where
and
is your where is your appeal
Your lordship, the appeal was filed dated
11th August 2024.
appeal was filed on
11th August 2024, man.
page 89
Page 100, man.
APL 01 APL 01 did you put in the pre-deposit
yes, your lordship.
where
Your lordship, in APL 01, your lordship, page number 99.
APL 01 details of pre-deposit yes 2 lakh no 2 lakh 24,000 yes
Yes.
And your lordship, there is another issue. Your
where is your application for condonation of delay what was the delay
your lordship, 148 days, your lordship.
148 days delay madam
143 days, your lordship.
140 days beyond 3 months
Yes, your lordship. Yes, your lordship. After 90 days.
you are appearing for
I'm for the petitioner, your lordship.
you are appearing for
For the petition. For the petitioner.
oh petitioner where is your explanation for the delay
Your lordship, page number 6, your lordship.
no in the before the appellate authority
So, your lordship, serial number. Condonation of delay.
you said the matter pertains to refund of GST
No.
No, your lordship.
what is the matter
Your lordship, the claim is the matter is about excess claim of ITC.
excess claim of ITC
It is availed excess ITC.
Your lordship, there is the
availed or availed and utilized or only availed
your lordship availed. Your lordship,
you did not utilize it
no, your lordship.
yes Mr. Chakraborty did not utilize just check it in the meantime yes you tell me
Your
when
lordship,
which paragraph Which paragraph before the appellate authority have sought for condemnation of delay?
Your lordship, page number 99, your lordship.
You say it is beyond 90 days? $142 delay.
Your lordship, page number 92, your lordship.
Is Mr. Chakraborty availed only?
The show cause notice, just I have received the brief now. 36 says, if tax short paid, tax liability on inward
Yes.
cause. That is the show cause. And ITC availed.
Inward, ITC availed inward B2B, such and such. Then GSTR, TSTR 2A is there.
And thereafter the order is at page, my lord, it appears possibly, my lord, they did not.
Non-contested.
Yes.
Actually,
Not, both of you cannot speak. Make up your mind. Who's going to suffer? Non-contested.
Yes, my, it appears so.
Your lordship, the petitioner.
Where is the order? Where is the order?
Your lordship, page number.
My lord, 38, my lord.
No, 42. 42.
42 is the, yes, summary is the 38.
The summary is not necessary.
No, he did not reply.
At no stage, ASMT 10, 11, nothing. Why?
And your lordship, there is another issue. Your lordship, the APL 02, after rejecting the appeal, APL 02 was issued after 2 days of appeal rejection, your lordship.
Neither here nor there. You have not responded anything. Yes.
Zero reply then condonation of delay.
ASMT 10, you did not respond. GSTR 1A, not GSTR. DRC 01A, you did not respond.
Your lordship,
DRC 01, you did not respond. Neither did you make payment in DRC 03.
your lordship, the petitioner was dependent on other people, so he couldn't.
What is your defense?
Your lordship, there is a merit in this case. If
What merit? Yes, tell me.
in page number, this is a case of excess claim of ITC, wherein the Bharat Petroleum, from which they have purchased the gas, your lordship, they have wrongfully shown in the return that it is B2C instead of B2B. And
No.
your lordship,
Yes.
the certificate is annexed in P8, your lordship. They have provided, the Bharat Petroleum has provided the certificate, your lordship.
ITC availed on inward B2B supply, correct? This much. ITC availed B2B supply net this much. ITC availed excess subsidy this much. Where is the ASMT 10?
It's not attached. Yeah, they have not issued, your lordship.
Yes, they have issued ASMT 10.
Order.
Then, your lordship, it's not attached, your lordship.
Was RP was selected for. No, show cause then the condonation of delay.
Your lordship, page number 20, your lordship. কি বলবো আমি?
Can you charge interest on this? You have also charged interest. Page number 30.
My lord, he has availed, my lord, he must,
Availing, so availing does not attract interest.
my lord, he had the entire, my lord, difficulty is, my lord, the entire thing is not very clear, but it appears to be that he has availed.
There appears to be a notice under section 61.
Scrutiny.
So there was a scrutiny.
Yes.
Pursuant to the scrutiny, this was detected.
Notice was issued. Now the show cause notice says, my lord. Show cause notice also includes the interest component.
Everything, how can you charge interest? I want to know. Section 50 does not authorize you to charge interest unless unless it is utilized. It has to be utilized for it to be charged in.
It has been utilized.
No, only your case is that availed. Your case is only discrepancy availed,
My lord,
not utilized. It is there in the credit ledger. Availed it in the credit ledger. It was brought down in the credit ledger, not utilized it. Not set off against utilization. Now, if it is that part is incorrect, that ought to have been reflected in the ASMD 10 or in the DRC 1.
my lord, what I find is what is there in the record, page 30. My lord,
Yes.
He has given a explanation as regard to the interest part.
Where?
Page 30.
Page?
Page 30, discrepancy number,
Yes, I've seen that.
in terms of section 50, my lord.
Correct. So section 50 does not provide for this. Section 50 does not provide for this. Read out section 50.
I remember this argument.
Yes, I have already decided this issue.
But I,
You had appeared. Yes, correct.
I
Yes,
remember that. Mr.
yes.
Mojumdar was appearing.
Yes. No, not Mr. Mojumdar.
Barbara Mojumdar, my lord.
No, this Miss Roy Chaudhury's matter, perhaps. You also appeared. Mr. Siddiqui also appeared in the matter. Yes.
Now we got the bill.
I understand.
Just now.
What will I do? I'll keep it here. I'll decide it. Why is not there in the Shattok?
We are not served to the GP.
Availed and subsection 3, availed and utilized. Mr. Siddiqui knows it very well. Availed and utilized. The language is very
Which
clear.
is clear. But at this stage, man, they chose not to appear, man, make on and send it back because there will be a factual issues.
Actual issues are there. I mean, have they been liable to make payment of interest? In the order, interest has been included.
Yes.
Yes, Your Lordship.
Yes.
Yes.
And what is the explanation, madam, in petition? Explanation, I'm not satisfied, madam. That is the reason why I'm looking into this. What is the nature of your disability?
Lordship, the certificate, medical certificates are attached here with your.
Yes. 50% I have understood.
Is handicapped, physically handicapped.
I understand that.
কি হাঁটতে পারে না
Lower portion handicapped, most probably, Your Lordship. I'm not well versed with that.
Oh. Limbs. Yeah, Mr. Chakravarti, you have a better copy. Page 19. Can you read it? Paralysis, no?
Yes, Your Lordship.
Lower limb. Paralysis. Can you read it out? At the top. We
No,
hereby
I
certify.
cannot. Copies.
I'll send it back in that case.
Your Lordship may also kindly withdraw the bank account attachment.
What is the amount? What is the amount?
47 lakhs.
Oh, you had paid the pre-deposit.
Yes, Your Lordship.
Yes,
Yes, Your Lordship.
Ashwin.
আপনারা স্বার্থকে দেন না কেন? You should be serving in a স্বার্থক. Well, they should be serving in স্বার্থক. I just received 5 minutes back.
This is not on Shartok.
No, they have not, my lord, I
Why
received,
is it not on Shartok? What is the
but
item?
they have not served to the GP office,
They-
that's
Your
why.
Lordship, yesterday itself, we came to know that it is not, they have not received the copy, but yet.
There is your affidavit of service.
Your Lordship, we have given the
Take
affidavit of
affidavit of
service.
service.
GP office এ দেন,
Yesterday
সেটাই
itself,
বলছি।
we came to know, Your Lordship, that they have not received any
No,
copy.
no, it's with the government pleader.
Government pleader has been served.
Yes, Your Lordship.
কবে করেছে?
One is GP, two is Assistant Commissioner of Revenue, three is Commissioner. Let me find out whether they have actually. Let me find out. Tangra office, Barashat, Tangra SO, Habra. Where is GP?
কি করেন?
Yes. Yes, madam.
Yes, Your Lordship, it is not served to the GPI, we just gave him.
Though affidavit of service filed in court is taken on record. will give that citation. Otherwise, শাশ্বতর কাছে আছে, শাশ্বত
Chakraborty, but I'm giving-
শাশ্বতর কাছে আছে, এসকে চক্রবর্তীটা দিয়ে দিও না। হ্যাঁ, দিয়ে দিও না। Yes, we call the next matter.
See, matter, your lordship has already passed several orders, my lord. This is that flour mill matter. Flour mill matter, my lord. Flour mill matters. Where, my lord, the
Please it, sir, I don't remember, sir.
may I hand over your lordship order?
Identical.
Identical issue,
This you had mentioned. This matter you had mentioned.
my junior man.
No, anyway,
এটা কি অরিজিনাল না শোকজ?
এটা suppose stage ছিল।
identical issue.
No, my lord, I give you lordship the difference.
My lord-
In this matter which has been referred to your lordship right now, here show cause has been issued and show cause was challenged. In respect of the issuance of show cause, this order was passed subject to correction. And over here, show cause was issued, show cause was challenged, writ petition was filed, no interim order was passed. Only direction for affidavit was there.
No, my lord, that has, my lord,
And now,
Which matter? Which matter?
my learned friend can wait for a moment and
Let me, I'll come back to you.
you are
And
making
and
incorrect
now-
submission.
and Now, my lord, adjudication order has been passed, which has been challenged in this writ petition.
May I submit now, my lord, to correct the factual, my lord, position? My lord, in this matter, my lord, your lordship, the issue is that I am doing the crushing of wheat on behalf of the state of West Bengal.
Yes, continue, sir.
Yes, my lord. So, my lord, the crushing is done on the state of West Bengal. My lord, the issue arose at the outset, my lord, as and when the contract was awarded to me. The position of the state government was very clear that it is exempt from tax. Because, my lord, it is covered under the purview of Article 243 and 243W, which, my lord, exempts any services provided to the state government. If it is an activity relating to services provided in relation to, my lord, the activity of the panchayat or the municipality. So, my lord, in that backdrop, my lord, the proceedings were going on since 2020. They have forcibly recovered an amount of 5 crore 50 lakhs from me at the stage of investigation itself. Now, my lord, which is, my lord, now there is a Supreme Court judgment in Radhika Agarwal that if any amount is recovered at the stage of the investigation, that has to be refunded. Right? That is
No,
another.
in this case, was there any advance ruling?
No, my lord, in this case, since we had filed for a refund,
Well, Mr. Sharaf, come to page number 6 of the order passed by this court.
yes,
What was the basis for this court to pass the order? Whether show cause or not, forget that. That is not relevant. But the basis for passing the order is paragraph 7 onwards. Why did I pass that order? Place it.
but there are two reasons. One is the jurisdictional issue, your lordship passed the order.
Correct. Jurisdiction
And
based on what?
secondly, there was an advance ruling.
Correct.
So in my case, my lord, the advance,
Jurisdictional issue was, I was also influenced by the advance ruling. My order was also influenced by the advance ruling.
correct. My lord,
You see, I have recorded that. Otherwise, I usually record whatever
not-
is there. Your
my lord, I am
submissions.
not disputing that. I am coming to that, my lord.
Yes, yes.
It is not that, my lord, I can hide all these facts.
No, why will you? Why will you hide?
It is part of my petition. I made that averment also.
Yes.
That there is a advance. I have enclosed that order also.
Advance ruling is there in this case.
Advance ruling, my lord, we filed an application for advance ruling.
Fine.
They said advance ruling can only be filed, my lord, if there is no, the matter is not sub judice.
Correct.
They said that since already you have approached for refund of the amount paid during the stage of investigation and which refund has already been denied. So since the matter is already sub judice,
What is the figure?
my lord, the amount is 8 crore 80 lakhs something, my lord, the demand. And we have already paid 5 crore 50,
This is under which act? This is under the.
we have WB GST and CGST both.
Are you ready and willing to secure?
But it is already secured. 5 crore 50 lakh has been paid out of 8 crore 80.
That is different. To challenge this ordinarily in an appeal, you have to secure it. I'll entertain your petition. Are you ready
No,
and
my lord.
willing to
My
secure?
lord, kindly consider. They have invoked section 74. My lord, kindly consider one thing only. Forget about the merit of the case. Whether I have a merit or not, that is another thing.
No, today we are considering only the interim.
No, my lord. interim your lordship is considering, I'm just pointing out one thing. My lord, this is a case which has been initiated by invoking section 74. Section 74 can only be invoked if there is an intent to willful suppression of the fact or intent to defraud the revenue. My lord, here on the basis of the Commissioner of Commercial Tax, my lord, the state tax, they have issued a notification that the activity which I am performing is exempted. The Special Secretary to the Government of West Bengal has written letter to the CGST authority that this activity is exempted.
Sir, I will hear you on this. Nobody is saying, after all, please understand, today, if this happens, if the matters wait for adjudication and nothing is paid, the revenue will be wound up. We are, after all, dealing with revenue. I have to strike a balance and hear.
My lord,
I
suppose,
have to strike a balance and hear it, Mr. Sharaf.
my lord,
You understand this.
out of 8,
How much? So, very well. 8 crores is the figure. 10% of 8 crores is 4 crores.
8 crore 73, 86, 826.
Very
is
well.
the
You,
figure.
you deposit not with me, deposit with them 5%.
My lord, already 5 crore 50 lakh has been paid.
No, then I will, then you make up your mind, sir.
No, my lord, I cannot ask the client to pay any further. My lord, it is contrary to
I'll
the
pass an
Supreme-
order of court. That is up to you.
My lord, kindly hear me, my lord.
This matter already covered. What will I hear you on this matter, Mr. Then final hearing it will come to. You want final hearing? I'll place it for final hearing.
Kindly place it for final because
Then
so
there
many
can be no
matters.
interim order.
Kindly allow us to file the affidavits.
Yes, no interim order in that case.
Let there not be interim order, my lord. If they want to recover further, they may recover because they've already recovered 5 crore 50. If they still they want to pressurize and they want to kill the
I am
industry.
not going to give them any blessings to recover from you. But at the same time,
Well, I will not press for
At the same-
interim.
you are not
If it is
placing.
subject to 5% deposit, I will not press for interim.
Naturally, sir, I have to work out a balance.
Well,
This
balance
court
is
has to
already there.
no, the court has to work out equities.
But
Equities
5
have to be
crore
balanced.
50 lakh, if it has already been recovered forcefully from me during the COVID period,
And
during
Mr. Sharaf, I have to ascertain on affidavits whether it is forcefully or without force. I cannot say
Well, it
today.
is part of
Does
my-
Mr. They acknowledge?
It
Then
is
I will say okay.
My lord,
He cannot acknowledge.
my lord,
right?
my lord, I am saying one thing, my lord. My lord, their own circular says, my lord, I am not carrying that circular.
Very well. I'll post it for final hearing in the month of August.
But just
Come
one
back.
thing,
Not much time, because I think by August we will be in a better position to deal with matters. So I'll be taking up some forwarders matters. In the month of August, come there. You may have a good case, but I can't grant any interim order in your favor.
well, let it be. Because I don't want
No,
to.
no, because that is so. Since the means
Merit
very serial 3A. But now you see, You see, the core contention is that notification 12 of 2017.
Yes, my lord.
Your core contention is the notification of 12/2017. Same here.
Notification, yes, same contention.
Same contention.
And 74. These are
that,
the
that
two
you claim
contents.
exemption on the basis of serial number 3A. Correct?
That is also, my lord,
No, is it your case or not? Tell me this, please,
my lord,
please, sir.
kindly, my lord, I place my case. My contention is that I am covered within 3A. But suppose if their contention is that they are saying that I am not covered under 3A because they are saying my cost of material is more than 25%. Whereas the notification uses the word value of supply. Value of supply, we have made the submission that the value of supply is 23% only. As per the consideration admitted by them. In the order also they have
No,
admitted.
this matter is little different from the other one. This is not covered by that one.
No, my lord, both the matters are the issue is
No,
the
no, issue is not identical. It's maybe variation is there.
only variation is, my lord, that there is no advance
Previous
ruling
matter,
here.
the question was of principal supply.
No, that issue is here also. Same issue, same arguments. I am not making different arguments. All that I am saying is that
Then if you consider that this matter can
let it be heard in the August, madam.
Yes, I'll place it in August. I'll place it in August. I have to hear you because
Yes.
I am not person who can, by looking at the file, decide a matter.
Yes, ma'am.
I need to apply my
Only
mind
of
to
the
decide
entry
the matter.
I'm
Since
not
you
going.
do not, since you do not insist for interim order, and considering the fact that your claim arises out of an exemption under serial 3 of notification such and
The
such.
only reason, my lord, I was just, my lord, I am not pressing it for this matter, my lord. I am not pressing interim because I have already paid 5 crore 50. So I am not pressing at all. All that I am saying, my lord, that if in the investigation, my lord, I am just generally I am saying, my lord, that if in the investigation something, there is now a Supreme Court judgment. That is just
I
wanted to
understand
bring
there
to
is
your
a Supreme
notice,
Court judgment, but without their affidavit today, whether on what circumstances that.
Such action at no point of time.
Mm.
And Lordship, he has in the
And the Supreme Court has also said two aspects. Very recently, there's another judgment in a bail matter where he had said, once you agree before the High Court that I am going to put in this amount for bail, subsequently,
that has
I
no,
just come across.
no, that my lord,
Yes, I need to read that. I've not read it.
No, I am telling you, Lord, see what has happened in that matter. What happened that for securing bail, the party concerned, the advocate concerned said that they have already paid 2.5 crore.
I'll pay
We
this much.
agree.
Yes.
We pay further 2.5 crore.
Then
But
onerous
then they gave to
condition cannot be put to bail conditions. Correct. He argued that before
They
the Supreme
themselves
Court.
agree before the High Court. Then they approach Supreme Court saying that the condition is onerous.
Correct.
So,
So
that is
therefore,
Supreme Court.
same point, Mr. Day is trying to argue today that you have accepted this position and not challenge it. You see, one cannot be permitted to approbate and reprobate at the same time. There's a provision in law, section 114, 115 of the Evidence Act, which deals with it. So there is an arguable case on behalf of the respondent also.
Let it be, my lord. Let
Yes,
it
so
be.
therefore, I cannot simply sit and say, I have to apply the judgment in the facts of this case,
Yes.
Mr. Sharaf. I will hear you out. I'm
Yes.
not saying any hear you.
Moreover,
Where is the order?
Virus has been challenged. Virus of serial number 3 of the notification. It has been challenged. Now he's trying to avail the benefit out of this notification.
Where is the challenge?
Telling us to page 49.
No, I have challenged it to the limited extent that it should not contain, that is covered by your lordship, that order. That detailed your lordship is covered.
Yes, I've seen it, but there
all
are.
the arguments has been recorded, my lord, in that.
Why will I
Whatever
not
my
record your
learned-
argument? You have argued this. Yes. But you have challenged the virus here.
But that matter, your lordship,
Wait. Here?
Where he
No, I'll read it. I have to read it. I can't. Yes. Oh, well then when is your service of the writ petition? देखिए, Attorney General is complete.
Yes, your lordship.
Have you checked up?
Yes, your lordship. It's in the last page, the track consignment status.
Attorney General is 30 IN.
27 of High Court Civil Procedure, High Court Appellate Side Rules.
Affidavit of service filed in court is taken on record. In a batch, I have to take up. In a batch, I have to take up. After August, I'll be taking up the now. After August, I'll be taking up the matters by finding out a schedule, preparing some sort of a time schedule so that I can take up. Previously, I was taking up matters. So I'll be trying to do that. Then you take your chance.
Great.
হ্যাঁ হ্যাঁ, এটা তো আমাকে, এটা ফাইলে না, এটা আমার কাছে থাকবে। Yes, I have got it, Mr. Chakraborty. Yes, sir, got it. Kundan Singh versus the superintendent of CGST. That bail matter.
Yes, yes. So they, my lord, they themselves agreed and they say the condition is onerous.
Same point, sir. So this becomes arguable for Mr. Day. You say the same day
Now, my lord, I don't
because
want,
they agreed before the court
no, now,
and
my lord,
not before the authority.
my lord,
You are trying to draw a
now,
distinction.
my lord, I don't want your lordship to now open the brief
No,
unnecessarily.
not that. Whenever you
Don't
come.
respond
Yes,
to that.
yes. When you come. Whenever you come.
In this matter, a very unfortunate incident has happened with the petitioner. Worship, the person, the accountant who was responsible to look after the income tax affairs of the petitioner, and years after years he has been looking after, has expired. And the email ID that was, the accountant's email ID was given as a registered email ID. And accountant's email ID was given as into the income tax department as a registered email ID of the petitioner. Lordship, after when the petitioner came to know about the sudden demise of the accountant, Lordship, he had got no access to any of his data. And Lordship, after that, he appointed an further a new.
How do you recover the user ID and password?
No, Lordship, the account he
You are
appointed.
saying you had no access to data. So how do you,
He cannot recover, Lordship. Not till today, he has not been able to recover, Lordship, because Lordship, the email ID.
see, is the only way to recover email ID?
He has substituted the email ID, Lordship. That has been stated in the petition.
No,
with the income
what is
tax
the way to
department.
recover user ID? What is the way to recover an user
Of
ID?
the portal, Lordship, income tax portal, Lordship. Lordship,
Everything is on portal.
no, Lordship, so far my instruction goes, he has not found it in the portal. Till today, Lordship, the assessment order is not uploaded in the portal. He has got a section 270A penalty order, Lordship.
Not uploaded on the portal. No, check up this part, because I would appreciate, I'll take care of what he is trying to suggest is that since email ID is not with the accountant, matter ends. No, it cannot end. You may find difficulty, but there are ways and means to recover a user ID and password with the attachment of the phone number. It usually has to be, phone number has to be attached. Now, if you say that it was the income tax account, not the accountant's phone number, then you have to give proof of that. It is not that easy. Ordinarily, sir, what happens is it may be the ID is of the accountant, but the phone number attached is of yours. He will not take that risk of attaching his phone number because he will be penalized.
What is stated in the petition, Lordship, the portal user ID password is recovered, but no assessment order is found in the portal.
Yeah, find out, Mr. Bhattacharya.
No.
Find out and come back. This I cannot help you today. What is the urgency for moving?
Lordship, the bank has been attached and the
Very good.
amount
So
of
when next week,
9 lakhs has been recovered. Lordship.
considering the fact that that the bank account of the petitioner has been attached. If he is no without the order, how can he prefer an appeal?
That's why I will take
And
instruction.
you have recovered 9 lakhs from him.
Addition 7 crores.
And maybe you have recovered 9 lakhs from him.
7 crores addition will not.
Maybe the addition is wrong. May happen. Today I cannot decide this. I am not an appellate authority. He has come with a justifiable cause. He says that I cannot access the order, not portal. Access the order on the
Sir, I
portal.
have to place your lordship whether the order is in the portal or not.
whether it is accessible by him or not.
No, my lord.
Now, the other day, there was a matter pertaining to section 54 of the GST. The issue there was the petitioner was unable to access the deficiency memo on the common portal issued in RFD 03. RFD 03 was uploaded, but the deficiency memo column was kept blank, means the documents column was blank. The petitioner's advocate accessed the portal after Mr. Bhattacharya was appearing, and it transpired that actually the view site of the portal for the petitioner was not common with the officer. The officer has uploaded it, but the view site was different. So you have to ascertain, that is your object, to ascertain whether the petitioner can view it or not. He may be viewing so many things. Unless, what is your object? Object is to make it available
Yes.
for him to challenge it. He has a right to challenge. If he does not challenge, consequences will follow. If he is unable to challenge, then he should not be rendered remediless. Find it out and come. He may have, the officer will say, I have uploaded. That is a different issue.
Change of password,
Yes.
it will take 5 minutes.
Mr. Bhattacharya need not explain this. That's why he may not be knowing, but anyone will know that not even 5 minutes. The moment forgot
OTP
password is there with the phone number, OTP immediately is over. Unless he says, no, the phone number is also attached with the, usually that is not done. And ordinarily what is done? No, ordinarily what is done
That is not
is in income tax, the person who is associated deals with the matter has the access to all the credentials. The credentials are, of course, of the assessee. The assessee does not find time till today. In many cases, I do not know whether in your case also it is done by someone else.
Yes. Absolutely, Miller. Absolutely.
But you have all the access and credentials. But in these private individuals' case, that may not be the same. Maybe the email or Gmail. Email is ordinarily a Gmail for them. They have no special mail they have. So that may be with the person concerned, accountant. So it is very natural. But it is very difficult to accept that he could not have recovered. That is a different issue. That I will take care. But you ascertain whether the order is there. Next week, same position.
Next week,
Next same position. He has to get some time. It's not no magic that he will get. If he writes a letter, the response will be, it is on the portal. I don't want him to ascertain that. I want him to actually ascertain whether it's in a view portal or not. Next.
টা বার করবো।
From that, from under section 149, the first comment section 150, that I is section 149, the second value, and this search was conducted on 15th February 2023, and one was under 150. After that, 148 notice was issued on 10th February 2024. This was for the assessment year 13-14. Assessment year 13-14. Over from 10 years. This is 10 years from the end of the assessment year relevant to the previous year in which the search was conducted. Search was conducted in 15th February 2023, that is 22-23. So the relevant assessment year is 23-24. Well, 10 years from the end of 23-24 brings us to the
কালকে
beginning of
লিখলামটা
14.
কোথায় লিখলামটা কোথায়
13 number.
Lord, your lordship, Lord, prima facie is taken a view, my lord. Yes, I know that. My lord, yes, yes.
13 number.
Assessment order.
After the assessment order,
My lord, because on 3rd March 2025, during the assessment proceedings, I had.
Stay was on.
Yes, my lord.
Or of the assessment order also.
No, my lord.
also no assessment.
Go and file.
No, I'll show my lord. I'll show my lord the difference.
Or now I'm not inclined to it.
No, my lord. On during the assessment proceeding, during the
You will decide. Since an order has been first,
no, my lord. During the assessment proceedings on 3rd March, I had sent a letter arguing the same thing, that this contention that it is barred by limitation.
you did not decide.
Did not. Yes, I'll show. My lord, takes page 98 of the writ petition.
First set.
First letter.
Page 98 of the writ petition, I sent a letter on 3rd March. My lord, sees page 100 where the chart is also given. The table is given. No, my lord, they did not consider this letter at all. In the assessment order, this letter has not been considered at all. My lord, this goes to the heart of the matter, my lord. This is absolutely without jurisdiction. My lord, 14 crores has been added beyond jurisdiction.
So, since it's a jurisdictional issue, my lord, your lordship entertain.
My lord, this is the Sanjay Sanganeria matter, my lord, as being led by Mr. Abrutosh Mujumdar. My lord, 9.5 crores is the demand, my lord. No, my lord, this is completely without jurisdiction. My lord has stayed the 148 notice. My lord has stayed. Because, my lord, I prefer going before the assessing authority. I wrote a letter to them. My lord, sees page 100. My lord, sees page 100 that my contentions are already placed before the assessing authority. Before filing the writ petition, we submitted to the jurisdiction by saying that they do not have jurisdiction to issue the notice. That we have said. My lord, I have placed it on record. They did not consider this at all and passed the order adding such a onerous. But my lord has.
My lord, argued the matter, your lordship pass an order. They carried the matter up to division. Today, my lord, yes, matter carried up to my lord division bench. Your lordship 10 crores limited to 7 crores an order. My lord, what I remember.
My lord, this matter has. No, my lord.
My lord, today, my lord, I will search out. Lord, they have come from the Mumbai. Some Deshmukh, my lord. Deshpande, yes. Deshpande.
Original side matter. Original side matter.
Mr. Ajoy, and Learned Advocate Mr. Ajoy Roy also appeared. Roy Chatterjee. Yes. Yes. Yes.
আচ্ছা ওই যেটা 3 দিন ধরে আর্গুমেন্ট হয়েছিল
Petition. In this petition, I'm simply challenging the inaction on the part of the respondent number one in not adjudicating which was entered on 30th of March 2020 and not considering made by the petitioner to adjudicate the show cause after parting with the document which you have requested in the reply and after no, your lordship. And after opportunity of personal hearing so that the proceedings can be because the proceedings were initiated in the year 2020.
My lord, my instruction. My lord, as per his, my lord, he has the taxpayer, that is the petitioner, has been making various representations with regard to non-receipt of the RUDs, and he did not appear as per my instruction on the adjudication process, which was fixed on 25 on 12 September 2024 and 12 November 2024. No, my lord. Subsequently, third PH was issued on 19th May 2025. Thereafter, my lord, he started writing letters to the department on 22nd May and 29th May, saying that we have not received the relevant RUDs in respect of the show cause notice, for which reply to the show cause notice remained incomplete. However, my lord, in order to avoid any controversy, by our email dated 30th May 2025 in the registered ID of the taxpayer, thus all the documents and everything has been sent.
The documents have been sent after filing of the strict petition. The petition was filed on June, your lordship, but the documents have been documents have been served on Google Drive and
That she is not submitting.
Permission. And for that, permission to access the documents. The documents are not open, and for that, the petitioner has written multiple letters to the department requesting for permission to access the documents, and that has also not been given. Yes, your lordship. And your lordship, my only prayer in this writ petition is that. Yes, your lordship. Your lordship, the only prayer is that the documents be parted to me and the show cause. No, your lordship, I can show you, your lordship, in my reply, which was filed to the show cause notice. It is on page number 220.